Hello, welcome back to another episode of the Law Review. I'm your host, Jacob Ayler of the Law Office of Riley and Ayler PC. Hope everybody's having a good week and a good month. Just wanted to touch base with all of you about a very common problem that I see in my practice, but it can also be a very complicated problem when it comes to estate planning, is dealing with blended families. You've probably heard rising statistics of divorce in the United States. It seems to go up every year. Right now, I think the last statistic I saw was 55% of marriages end up in a divorce. And unfortunately, those numbers keep rising. And so as a result, it's very common for me to get clients that come in that are blended families. And you might ask what a blended family is. I don't know that there's a legal definition, but my definition is one where you have a couple with children from different relationships living together. So I really see this in kind of two situations. One is I'll get people that will come in that either had a child in a previous relationship or a previous marriage that have since remarried, and maybe they have some children of their own now. Or I'll also see families come in that perhaps they lost a spouse and they might be in their 60s or 70s or 80s, and they've since remarried somebody else who has also lost a spouse. And that's pretty common for people that are seeking partnership later in life. But the big wrinkle that comes into these types of estate plans is making sure that you take care of your children and your current spouse. One thing that often comes up is people want to provide for their spouse in the event that they should pass away, but they also want to make sure that their children, who are also very important to them, are taken care of. Which is why a simple will set up for a situation like this doesn't work, and there are effective and specific estate planning strategies that have to be used to make sure that works. For example, I have had couples to me come in and say, well, I got remarried, I need to do a new will, but what they fail to realize is that they could unintentionally disinherit their own children. For example, if I had a couple come in once where, the wills left everything from one spouse to the other, but a lot of people fail to understand is that once you give something through a bequest and a will, that becomes the property of who you leave it to. So if you leave it to your wife, then it is her property. And unless there is some specific estate planning document that says otherwise, once you leave that person a house or money or valuables, they're free to give it to whoever they like. And so what could happen in that situation is you could leave everything to your spouse, who could then change her will or his will and leave everything to their own children, and your kids get nothing. And that's one thing that comes up. Another issue that I've seen come up is when there is a big gap in age between someone. For instance, we all know those couples where you've got somebody who's in their mid-60s who has married somebody who might be 20 or 30 years their junior. If they have a trust agreement that delays their children receiving anything until the spouse dies, it could be 20, 30, 40 years before that happens. And what often happens is litigation gets started because kids believe that the former spouse is taking large distributions from the trust, or that she or he is spending all the money and they're not going to get anything. And so those situations are ripe for litigation. Another big concern is when you have blended families with this type of situation. If one of the two people end up in a nursing home and having to pay a substantial amount of health care, a person's inheritance could be eaten up to fund that care. And so what I like to do is talk to people about what their problems are, what they want to accomplish, to make sure that they can still take care of their current spouse, but not leave their children that they may have had from another relationship or another marriage, so that everybody is taken care of and it's done effectively. This can be done a number of ways. It can be done by direct beneficiary designations. It can be done by what I call, and there's a lot of different names for it, but I've prepared what are called bloodline trust, to make sure that the wealth, whether that be real estate or money, is transferred directly in the bloodline of a certain individual, so that if something happens to somebody else, and money goes to a child, if there's a divorce or something like that in the family, it prevents that other person getting a large chunk of the inheritance. It can also be done through prenuptial agreements, which in Indiana are not highly favored, but they are legal. So these are all types of things that I think people should really consider when they're thinking about what they're going to do with their estate plan. I will tell you, as a matter of law in Indiana, the one question I get all the time is, well, I had a former wife, but we got divorced and she's still named in my will. By operation of law, courts generally treat that as a no longer valid transaction once a divorce is in place. However, it can make things messy. The other thing is, people should be aware that there is a thing called a spousal election in Indiana, where unless you have something set up differently, your current spouse is able to take against your estate, and take what's called a spousal election as a matter of right, and that's defined by Indiana law and Indiana statute. So these are all moving parts that, if left undone, could really make for a mess and lead to fighting, and hurt feelings, and it could also lead to somebody's assets being spent fighting litigation, to where by the time everything's done, the money or the property you may have wished somebody to receive is gone, because the estate had to incur substantial legal fees because everybody was fighting it. So I think moving forward, with the tendencies that we see in the increase of divorce filings every year, and certainly they're up again this year in Indiana, this is a problem that is not going to go away. And I would advise everybody, if you've have a child from a previous relationship, if you have been divorced and have children with your new spouse, you need to get this done, because if you don't get it done, it's only going to get worse. And it's something that, if done effectively, can be taken care of. So no matter who you talk to, you need to talk to an attorney to get that straightened out, to make sure that everybody that you love and care about is taken care of. If there's no hard feelings, and at the end of the day, you can leave a rich legacy for those that you leave behind. Until next time, I'm Jacob Ayler of the Law Office of Riley and Ayler PC. Please feel free to email me any questions or give me a call. I'll be happy to talk with you about what kind of options you might have available to you. Until next time, thanks.